Hello, my name is Haitham Amin. I go by Sam. I'm the principal attorney here at Amin Law in San Francisco, California. Today, we'll talk about what happens to debt when you die. Understanding what happens to your debt after your death is an important part of estate planning. Knowing the laws can help you plan carefully so that your family is protected. You might assume that when you die, your debt just dies with you. Unfortunately, that's not always the case, and there's a lot you need to know so you can protect your family. Estates and debts. If you're wondering what happens to debt when you die, it is important to understand how all of your financial affairs are handled after death. When a person dies, all of the assets and debts in their sole name are part of their estate. If you have a will, you have chosen an executor. If you die without a will, an administrator is appointed by the court. Your executor or administrator, uses your existing assets to pay the debts left in your name. Creditors are always paid before your beneficiaries. Once your debts are paid, whatever assets are left will be distributed to your heirs. The debts do not pass to your heirs. If you have more debts after death than assets, there will be nothing left for your heirs. The debts are then a loss taken by the creditors. What happens to credit card debt when you die? Worrying about what happens to credit card debt when you die or someone dies is a common concern. Credit card debt after death is treated the same as any other debt. If the debt is in your name alone, it is paid through your estate. However, if you have a credit card debt when you die and the account has a co-signer or joint owner, that person becomes responsible for the debt. Authorized users are not responsible for your debt, credit card debt rather. Mortgages. A mortgage in your sole name is handled like any other debt and death. It is paid off through your estate. If your spouse co-signed the mortgage, he or she is legally responsible for the debt when you die. If you have a surviving spouse when you die who is not a co-signer, he or she is entitled to take over the mortgage, even if it's in your name, without having to immediately pay off the balance. The spouse, however, will need to qualify for the mortgage and continue to make payments. A home equity line of credit must be refinanced by the surviving spouse unless the spouse co-signed the loan, in which case he or she is responsible for the loan. Passing property with debt. If you leave a piece of property to someone that has debt attached to it, like say a home loan, mortgage, or a car loan, the debt will pass through with the property. It is the responsibility of the new owner to refinance the debt or sell the property to satisfy the loan. If you pass a piece of property that is worth less than the debt, such as a home that is, say, underwater, the debt will be settled by your estate. If there are not enough other assets to cover it, the property will be sold to cover the debt. Community property and debt. 10 states have community property laws. That includes Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. In Alaska, couples must opt in to have communal property. In these states, any assets or debts acquired during the marriage belongs to the other spouse as well. So if you reside in one of these states, die and leave debt in your name alone, your spouse is responsible for this debt. Student loans. Some student loans, such as Federal Perkins Stafford loans, provide loan forgiveness if the student dies before paying them back. Thus, the loan is not deducted against the estate. There is also forgiveness of Federal Plus loans taken by parents if the student dies. Protecting assets from debt. Not all of your assets can be assessed by your creditors after your death. Accounts that have beneficiaries like IRAs, 401ks, life insurance, pension plans, and brokerage accounts are not accessible to creditors. If you place assets in an irrevocable trust, they are also immune to creditors. Protection for families. Although it is very clear your family is not responsible for debt in your name alone, with the exception of community property states, of course. This does not stop some lenders from sending notices to family after your death to try to collect on debt. They make calls and they harass family members and they try to trick them. If the demand continues, an attorney can step in and put a stop to it. Thank you for watching. If you enjoyed this video, I would greatly appreciate it if you can share it. Of course, don't forget to like, comment, and subscribe. Bye-bye.